Dhaval bhai,
Huh. Should I?
आप live છો? I have just rang you. You are live. You can start.
Okay, thank you very much. Good morning, young friends aspiring to be associated with the legal profession soon. Good morning to the faculty of GLS Law College, and thank you all for inviting me to deliver a talk on the topic which I like the most. But before I turn to the topic, let me confess one thing, that I am not used to webinar much. I used to take lectures in law at Law College as also at IIM, but it was classroom interaction. So my position is like an opening batsman in a game of cricket asked to bat an altogether newly laid turf. So if I am not audible or visible, you can interrupt me and tell whether I am bearable or not. That you can definitely tell me at the end of the lecture. Now coming to the topic, force majeure, a prism view in pandemic. When the topic was suggested to me, I said this is the right time to speak on this topic. Because today, all our social contracts, I will put it this way, social contracts, right to live, right to enjoy life, every facet of life by which the life is enjoyed, is in a void state or in a state of suspension on account of the present pandemic. So I think that when we are facing a situation of this nature in our day-to-day life, it is the right time to speak on the topic which has got bearing on commercial transactions. Now, when you put anything into a prism, you will find various facets. So when you consider force majeure as a concept of law, through prism, you will find multiple questions. The first question which requires consideration is, what is the true import of the term force majeure? What do you mean by the term force majeure? The second important question is whether the present pandemic on account of coronavirus can qualify as an event of force majeure or not. And the third important question, which according to me the most important question, is what is the impact of force majeure on the contract? So far as the third question is concerned, once we refer to it, so many sub-questions would also arise. Now let us begin therefore with the first question. What is the true import of the term force majeure? What do you mean by the term force majeure? Now you will be surprised to know that the term force majeure is nowhere defined under the Contract Act. Forget about the definition. You will not find the reference of the term force majeure in any of the provisions of the Contract Act, including the provisions which deal with the aspect of force majeure. Therefore, let us try to understand what do we mean by force majeure legally speaking. Now, force majeure is a French term and it is an expansion of a Latin term called vis major. Vis major means an act of God. Traditionally speaking, all kinds of natural calamities such as earthquake, flood, cyclone, drought, lightning, they were considered as acts of God, and in Latin term, vis major. Now, with the passage of time, with the development of the commercial world, a need was felt that there may be certain non-natural events. Strictly speaking, they would not qualify as an act of the God within the concept of the term vis major. But nonetheless, these non-natural events would also have a same kind of impact on commercial transactions, affecting civil rights of the parties as the events of vis major would have. And with this, the concept of force majeure was developed. So force majeure, a French term, would mean, legally speaking, though there is no universal definition of the term force majeure. So if one has to gather the concept of force majeure, one has to make an attempt to define the term force majeure, taking clue from various judicial pronouncements. One can say each and every event over which the parties to a commercial transaction, broadly speaking, contract, have no control. So something which is beyond the reach of the contracting parties, the happening or non-happening of which is not within the control of the party to the contract. The contracting parties have no string in their hands to control these events. They are called force majeure. They may be natural events, natural calamities. They may be non-natural events. For example, strike in an industry, breakdown of machinery, all of us are in an industry, change in the policy of the government affecting a particular commercial transaction, or change in the legislation by the government. All these have been construed, depending upon the particular fact situation, as events of force majeure. Therefore, something which is beyond the control of the party to the contract, when they entered into the contract, which they were not in a position to foresee, with a right to control over it, all such events would qualify as force majeure. So, if you compare the term force majeure with vis major, one can say that an act or an event which qualifies as vis major, an act of God, is undoubtedly an event of force majeure, but the converse is not always true. Because as I said earlier, force majeure is a term of wider connotation, and it would include both natural as well as non-natural events, acts over which the contracting parties have no control. So with this, it is now very clear what do we mean by force majeure when it comes to a commercial transaction concerning a contract. Now the next question is, which is also in the present scenario of great significance, and we often receive queries on this, and that is whether the present endemic, the present pandemic with which we all are suffering, the present pandemic which has led to the lockdown, on account of the coronavirus, whether that would qualify as a force majeure or not. In my opinion, present pandemic would undoubtedly qualify as force majeure. There is little scope for any debate on this, because when you look at the judicial pronouncements, you will find that strike, as I mentioned earlier, in an industry, breakdown of a machinery in an industry, change in the policy of the government affecting a particular commercial transaction, change in law making particular commercial transaction impossible to go through. All these have been construed as events of force majeure. So taking clue from this set of judicial pronouncements, so one has to test the present pandemic. In my opinion, it would definitely qualify as force majeure or an event of force majeure. Therefore, there is no need of further debate on this, in my opinion, though there is no binding judicial pronouncement of any court of competent jurisdiction declaring as of now the present pandemic as force majeure, and therefore I have guardedly say in my opinion, because but time will tell as and when the occasion arises for the courts to consider the present pandemic as force majeure or not. But if you look at the judicial pronouncement of past, referable to more or less similar situation, in my opinion, the balance tilts in holding force pandemic as a force majeure. Now, the third important question, which is of great significance in present scenario, what is the impact of force majeure on a contract? Because once you say force pandemic is a force majeure, it remains to be ascertained as to what extent it would have a telling effect on the contractual obligations arising from a party, more particularly when one party is claiming that this force majeure has adversely affected him. Resultantly, it is not possible for that party to discharge its contractual obligation. Now, so far as this question, which is of vital importance, as I said, is concerned, the first point is that the impact of force majeure on the contract would depend upon how the contract is worded, if it is a written contract. So one has to look at the contract first and try to ascertain as to whether the contract has made a provision for a force majeure or not. If the contract has made the provision for force majeure, Section 32 of the Contract Act would come into play. Now, before I take you to Section 32 of the Contract Act, let me give a hypothetical example to explain the concept and more particularly the impact of force majeure on a contract when a provision has been made in a contract for the force majeure. Say there is, let us, a hypothetical situation we may visualize that an Indian company enters into a contract with a company based in Pakistan. And the contract is for export of some chemical manufactured by the Indian company in India. Now, when the contract is entered into, the relationship with the two countries, India and Pakistan, is very cordial. Trade is permitted. So, export of chemical from India to Pakistan was a permissible trade. There was no ban, there was no restriction. But the parties to the contract had an apprehension that it may happen that after the contract is executed and while it is being implemented, there could be a warlike situation or there could be an actual war. There could be a ban on export of any material from India to Pakistan. So they decided to have a provision in the contract. And they defined force majeure in the contract. And while defining the force majeure even in the contract, they included war between the party, war between the two countries as an event of force majeure and stated that in such war takes place, the contract would become void and it would not be required to be performed and neither party would have a claim against the other party. That's what the contract is worded. Now, when you made a provision in the contract of such a nature, taking care of the situation arising on account of force majeure, the terms of the contract would govern the relationship between the parties. There is no need to search for anything else. You look at the contract only. Now, why? What is the rationale behind this? The rationale you will find in section 32 of the Contract Act. Now, section 32 of the Contract Act is with reference to contingent contracts. Section 31 of the Contract Act defines the term contingent contract. Now, as per section 32, read with section 31 of the Contract Act, if the performance of a contract is dependent upon happening or non happening of a particular event, that in that scenario, if that particular contingent event either happens or does not happen, as the case may be, the performance of the contract would depend upon that. If that contingent event, the happening of which was to make the contract to go through, and if that contingent event does not take place, then the contract would fall to the ground and would not be required to be enforced. That's what, in substance, section 32 read with section 31 of the Contract Act lists. Now, you will not find again any reference of force majeure in either section 31 or section 32 of the Contract Act. But nonetheless, while interpreting the scope of section 32 of the Contract Act, now we'll see Contract Act was enacted in 1872 by Sir Stephen and Sue. See the masterpiece of legislation that today also it works very well. Now, The courts have consistently interpreted Section 32 to mean that if force majeure event is defined under the contract and the impact thereof on the contractual obligations of the party to the contract is also defined or is also prescribed therein, then in that case, Section 32 would come into play and that particular contract would be construed as contingent upon or dependent upon the happening or non-happening of that particular force majeure. Therefore, coming back to the example which I gave, when party to the contract provided in the contract itself that if war takes place or a warlike situation arises and for some reason the export from India to Pakistan is prohibited, it is not made possible, then in that scenario, the contract would be construed as having come to an end. So that particular provision would fall within the purview of Section 32 of the Contract Act, and on account of that provision in the contract would no longer be required to be performed. Now, therefore, what is the lesson from this when you have to draft a contract? The lesson is that when you apprehend or perceive at the time of entering into a contract an uncertain future event, the actual happening or non-happening of which is not within your control, but if that even happens or does not happen, will have a great impact on the performance of the contract or non-performance of the contract, as the case may be, then in that case it is open for the contracting parties to make a provision for the same in the contract at the time of entering into the contract, so that in future, while the contract is in operation, that anticipated event of force majeure takes place, the rights are governed by the contract itself, and that too in the manner in which they thought. Now I'll give you a classic example of application of Section 32 in our day-to-day life. If anyone you have taken the trouble of closely reading your air ticket when you go for any air travel, just read your air ticket. You will find one of the conditions, though depending upon the airlines, the wordings may be different, but in nutshell, in substance, that particular condition in your air ticket would convey that if for any unforeseen reason beyond the control of the airline, it is not possible to have the flight as per its schedule and the flight is required to be cancelled, the airline company will not be liable for anything more than refund of the entire fare or credit of that fare, or if any alternative flight is available, an option will be given to you to go by that alternative flight. So they are restricting the liability. They say that we would not be liable for anything beyond this if for any reason beyond their control there is a force majeure, there is some breakdown in the machinery, or some aircraft is having a problem, or the air traffic is such that clearance is not given. So for any reason, if the flight is not in a position to take off, it is cancelled, the airline company will not be liable for you beyond a particular thing, and that is refund of the fare. There is first option. Second, that if you want a credit, they will give you a credit for that, so you can use it in future. Or if you are prepared to go by an alternative flight which they are providing, you will have to go. Meaning by which, on account of this clause in the contract, a further scope for any dispute is prevented. So when you enter into a contract and you apprehend at that point of time that there is a possibility of some kind of force majeure taking place, vitiating the relationship between the parties, having great impact on the performance of the contract, in that scenario, it is within your right, as per section 32 of the Contract Act, to make a provision for the same. And if you have made a provision for the same, then the rights of the contracting parties are squarely governed by that particular provision, and nothing else could be looked into. There is no scope for any other argument. You have to look only at the contract, because you have agreed to abide by that particular term in the contract. Now, issue may arise, as is happening at present, because in majority of the contract, because nobody visualized that such kind of pandemic will take place. So even in the contracts which have been executed so far, you will hardly find a reference of pandemic as a force majeure and providing for the consequences or how relationship would be governed if it takes place. So in that scenario, the question may arise that if the parties have chosen not to make a provision for force majeure in the contract, the contract is absolutely silent. Let's take a very example which I gave, very same example of Indian company entering into a contract with a Pakistani firm, Pakistani company, for export of some chemical to be manufactured in India. Now, there is no force majeure clause, nothing has been provided, the contract is absolutely silent. After the contract is entered into, and while it was in progress, war takes place between India and Pakistan. Export is now not possible. No provision made in the contract dealing with such situation, so you can't look at the contract. So, in this scenario, suppose the Pakistan-based company is required to go for that particular chemical from some other country by paying extra price, without you saying that its manufacturing process is not halted, and it would like to file a claim for damages upon the Indian company, saying that on account of failure on the part of the Indian company to deliver the chemical by way of export, and therefore it has suffered a monetary loss. The question is, would that claim be sustainable? Because there is no provision in the contract. Had there been a provision saying that contract would come to an end, as I said earlier, it is not posing any difficulty. But here is a case where contract is silent. What is the remedy in that situation? Because the breach on the part of the Indian company is not a deliberate breach. It would definitely like to export chemical from India to Pakistan to fulfill its contractual obligation. But nonetheless, it is prevented on account of war, pursuant to which the government of India has declared a policy barring all kind of export, all kind of trade relationship between the two countries. In such situation, when the contract is silent on the aspect of force majeure, Section 56 of the Contract Act would come into play. So, first, when there is a provision for force majeure in the contract, you have to look at the contract, go by it, follow the mandate of Section 32. If there is no provision in the contract for force majeure, the contract is absolutely silent. Or there is a provision for force majeure in the contract, but the kind of force majeure with which the parties are in a particular situation, as it happens today, that pandemic, that particular kind of force majeure is not contemplated by the contract. In either situation, I again repeat, in a situation where there is no provision for contract, no provision for force majeure in the contract at all, the contract is silent, or the contract has made a provision for force majeure, but that provision is not capable of taking care of the particular force majeure event faced by the party to the contract, as it happened in most of the cases at present, because no contract contemplated pandemic, as I said earlier, as a force majeure. So in that scenario, Section 56 of the Contract Act would come into play and would govern the situation. Now let us try to understand what Section 56 is. Excuse me. Now Section 56 of the Contract Act, if you have a look at it, and I would like to just read for you Section 56. The first part of Section 56 says, an agreement to do an act impossible in itself is void. Here is the first part of Section 56. I'm elaborating in a minute. The second part is a contract to do an act which, after the contract is made, becomes impossible, or by reason of some event which the promisor could not prevent, becomes unlawful, becomes void, when act becomes impossible or unlawful. Let me now dissect and elaborate this. The first part of Section 56 says an agreement to do an impossible act is void. Now you may appreciate here the word used is agreement and not the contract in the first part. So agreement to do an impossible act is void, meaning by which such kind of agreement would never assume the shape of a contract. Just slightly deviating from today's main topic. You see, there is a thin line of demarcation between the term agreement and the contract. So often these two terms are used as synonym, but in terms of law, there is a thin line of demarcation between the term agreement and the contract. When parties arrive at consensus on a particular transaction, say one party puts an offer, another party accepts it, the resultant effect is an agreement. Now, if that agreement is enforceable at law, it becomes a contract. And therefore, we often say that all agreements are not contracts, but all contracts are agreement. So first part of section 56 says that an agreement to do an impossible act is void. Suppose, let's give a very simple example which is also given in the contract act itself, that if someone promises that I have the magic, and with the aid of the magic which I have, I will find treasure for you, or you pay me some amount and I will show moon in your palm. All these are the contracts to do impossible, agreements to do impossible act. And therefore they are in law construed as void. They are never given the shape of a contract. Now taking clue from that first part of section 56, the second part of section 56 says that, well, when you enter into a contract or first agreement, you undertake to do something which is possible, which is not impossible. Therefore, it gives rise to a contract. So you are entering into a contract. Something which you have agreed to perform is possible, is permissible in law, and therefore it is also an enforceable obligation in law. Therefore, it is a full-fledged contract. But a situation may arise beyond the control of the contracting parties, whereby the performance of the contract, the purpose for which the contract is executed, the object for which the contract is executed, becomes either impossible or unlawful. Try to understand that parties, when they enter into a contract, they agree to do something. That performance of the contract was absolutely possible on the day on which they entered into a contract. But at a later stage, for the reasons over which they have no control, that particular performance becomes absolutely impossible. So in that scenario, the issue is, what would happen to the parties? And there the section 56 says that if something which was impossible when you enter into agreement is held to be void and will never give a rise to a contract, if something which becomes impossible or unlawful for its performance after you enter into a contract, obviously from that particular moment, that contract is required to be declared as void. Now, therefore, let us go back to the example. Same example with modification in the little facts. As I said, that parties, Indian company entered into a contract with Pakistan-based company. No provision for war as a force majeure in the contract. Contract absolutely silent. War takes place. Indian company is unable to export chemical to Pakistan. Pakistan-based company in turn is required to go to another country to purchase that chemical, has to dig out more money, incurs losses, and would like to claim that from the Indian company on the ground that on account of your failure, I have suffered this. Now here, on account of section 56 of the Contract Act, the claim of the Pakistan based company will fall to the ground. It will not be a sustainable claim, because on account of war, which is an unforeseen event over which party to the contract had no control, that particular situation, which is nothing but an act of force majeure, has prevented the performance of the contract. The performance of the contract became absolutely impossible. On account of the ban imposed by the government of India, trade between the two countries is not unlawful. And therefore, for the reasons beyond the control of that party, after the contract was entered into, the performance of the contract is impossible. And therefore, as per section 56 of the Contract Act, though there is no provision in the contract, by operation of law, the day the war is declared, the day the ban was imposed by the government of India, that particular contract would become void. The contract would be construed as having been frustrated. And therefore, in law, it is called discharge of the contract by frustration. By implication of law steps in. Section 56 steps in. And it would say that parties are no longer under obligation to discharge their respective contractual obligation, because the performance of the contract has become impossible for or an account of an event which is beyond the control of the contracting parties, that is force majeure. And therefore, the party who has to suffer, here in this case Pakistan-based company, will not have any claim, because contract itself is to be considered as void. Now, issue arose in one of the cases that the word used is impossible. Sometimes it may happen that physical performance of the contract may be possible, but it may not be practical, in a sense that that physical performance of the contract, though possible, would not subserve the purpose or the object for which the contract was entered into. And therefore, the issue arose for the first time in the year 1903 before English court, in a famous case of Crale versus Henry. Crale versus Henry. And the issue was, what is contemplated as impossibility of performance by section 56 of the Contract Act is a physical impossibility or a impossibility other than the physical impossibility, meaning by which whether impracticability of the performance is also covered by the expression impossibility or not. And once I explain the facts of that case in nutshell, the issue will become very clear. Now, what happened in that case? Crale was the plaintiff in that particular case, was having a property in a prime location in the city, and he was interested in giving his property on rent to anybody who wanted to witness a coronation procession where king was to be crowned and procession was to take place on rent. So Henry, who was interested in witnessing that particular procession of king with his family, approached Crale, the plaintiff. A bargain was struck, and that particular apartment of Crale was booked by Henry in advance for 2 days, which were meant for the procession to take place. And he paid advance to Henry, and balance was to be paid on the date on which Henry was to occupy that particular apartment for the purpose of witnessing that procession. Now, what happened that before that particular date on which the procession was to take place, the king became ill. And on account of that, it was not possible to have the procession. So Henry refused to occupy the apartment and refused to pay the balance amount of the rent. Creel filed a civil suit for recovery of that balance amount of the rent on the ground that there was a concluded contract. It was never dependent upon as to whether possession would take place or not. In turn, Henry took up the plea that performance of the contract was not possible because I had taken that particular apartment on rent for the purpose of witnessing the procession, which was not now possible. So he pleaded frustration of the contract, placing reliance on Section 56 of the Contract Act. In turn, Creel, the plaintiff, contended that physical performance of the contract was possible. He could have very well occupied the apartment and stayed in the apartment for 2 days. The court took the view in that particular case, interpreting the scope of the word impossibility, figuring in Section 56 of the Contract Act, to mean that it's not mere physical impossibility. In a given scenario, it may be possible to have physical performance of the contract, but if that physical performance is not going to subserve the object for which the contract was executed, then in that case, it is required to be construed as a impossibility within the meaning of Section 56 of the Contract Act. And the contract is required to be declared as void. Now, with this, if I have to say as a proposition of law, I would say that the impossibility to perform the contract, within the meaning of Section 56 of the Contract Act does not mean physical or literal impossibility. Even when physical performance of the contract is possible, despite some supervening event, despite some force majeure, but that physical performance is not going to subserve the object or the purpose for which the contract was executed, the contract would become void on account of the doctrine of frustration of the contract embodied in Section 56 of the Contract Act. Excuse me, I'm told that there is some query, so let me just check if some query is there. I may just deal with it simultaneously. I got on mobile. No, sorry, I am unable to read. The query is that am I able to read any query? Sorry, I am unable to read any query on my screen. So if any query is there, you can raise me in some other mode, either on my WhatsApp or you can. Yes, there is.
Yes, Dhaval bhai.
Query is not there. I am not unable to see.
Where are they? Shall I read them for you, sir?
You can interrupt me. No difficult. You are at the end. Whatever may convenient to you. I am comfortable. Depending upon the time slot, you can say. Now it's 51 minutes, so I think we have got time, not till 20 minutes.
Yes, sir. At your convenience, completely.
Okay. So if the query is there, if the query is there, I can simultaneously deal with the query. No difficulty. Fine.
Sure, sir. Few comments are there that it is very well explained definition and meaning of force majeure. All are very happy to understand and heard it from.
So what's the query?
Dhruv Thakkar, he wants to ask that is there any way to make a grant of relief from the electricity company to curb the minimum charges, where the commercial shops or offices which were not allowed to open or the force majeure will apply?
Yes. My answer is no. In my opinion, of course, it's my opinion because no court of competent jurisdiction has ever ruled on this. But if I have to opine, based upon the case law of which we are having at hand today and to which I am going to make a reference also, this would not be possible because you can't say that on account of force majeure, the pandemic as a force majeure, you are unable, of course, physical usage of the office is not possible, but your contract with the electricity company to pay minimum is not anyway dependent upon the fact as to whether you are in a position to use the office or not. So according to me, you will not be in a position to claim this as a force majeure. And I'm about to give an example because often I'm also receiving number of queries that, and it happens. Say, for example, particularly in the malls, people have got the showroom shops on the rental. And we also receive queries that during lockdown, we are unable to use the premises. We are unable to use the showroom. We are unable to use the shops. How can the owner of that particular shop or a showroom or the owner of the mall, if you have taken from him directly, claim rental from us during this period? And to which my answer is that, well, your contract is not frustrated. You see, you have taken, say, for example, you have taken a shop on a rental basis for a period of 2 years. It's a temporary phenomenon. Pandemic is not going to last for infinity. So the contract is to make you available that particular shop which he has made available for 2 years period. Now that particular contract was never dependent upon the fact that you should be in a position to actually use the premises in the manner you like. Your control, your dominion over that particular shop is not lost today on account of pandemic. It's a different thing that on account of some measures imposed by the government, you are unable to use that particular shop. But that does not mean that foundation of the contract is lost. Now I'll give you another example to bring home the point. Say, for example, someone has booked a party plot for a marriage function in advance. Booking is for only 2 days or a 1 day for the function. Now on account of the pandemic lockdown, it's not possible to make use of that particular party plot. Here you can say that contract is frustrated and I will not pay, and whatever advance I have paid to you, you must refund to me, because taking clue from the case of Cale versus Henry, the object of that particular transaction was to use the plot for a marriage function on a particular day, and it's not possible. In your case, in the case of an electricity company example which Dhruv Thakkar has just put to me as a query, you see, it was never understood between the two contracting parties, electricity company and the consumer, that for any reason for a particular period I am unable to go to my office, I will not be liable to pay the minimum charges which you are levying against me. No, I'm saying that. Now, if I go further, perhaps the issue would be better clear, because let us go to the judgments, reported judgments. You see, there are 3 judgments, and this will also help me in explaining the query which has been put to me. And I wish all of you to read these 3 judgments on force majeure which the Supreme Court has delivered. The first landmark judgment of the Supreme Court on interpretation of section 32 of the Contract Act, read with section 56, both dealing with the aspect of force majeure, is Satyabrata Ghosh versus Mugniram Bangur and Company, reported in AIR 1954, Supreme Court, page number 44. Now let me give you the facts of the case in nutshell. I am just trying to tell you the salient features of the facts to bring home the point. Here, what happened that defendant Mugniram Bangur and Company, we may call it a company for short, the defendant company was owner of a huge parcel of land in city of Calcutta having a prime location. This defendant company decided to develop this land for a residential purpose, and as a part of its development scheme, it announced that the entire land would be divided into subplots of suitable size. Then they would be developing basic amenities like internal roads, drainage, garden. So these subplots with this common development facilities would be sold to those who were interested in setting up their residential houses on these subplots. So it advertised like that. The intending parties booked subplots, and the terms of the contract were like this. Then at the time of the booking, you make the payment of earnest by way of advance, and the balance consideration for acquiring the subplots with the development attached to it was to be paid as and when the development was over and sale deeds were to be executed. So concerned parties made the payment of earnest, got their subplots booked. Then what happened that on account of second World War at that point of time, major chunk of this land, this parcel of land, was requisitioned by the government for war purpose. So this defendant company lost possession of major portion of this land. On an account of that, development activity on this parcel of land was not possible. This went on for a quite long time. So realizing that if this development we have to carry out in a later stage, it may not be a viable proposition because company had agreed for a price prevailing at that point of time, keeping in mind the price cost they will have to incur for development of that particular land. So they wrote to each and every purchaser of subplot saying that, look, if we give you the option, you take back your earnest which you have paid to us, and we treat the contract as having come to an end. We terminate the contract. Second option was that you take the subplot from us, we'll execute the sale deed, you pay us the full consideration, and we undertake to develop the land with internal roads, drainage and other facilities. As and when the requisition is released, the land is released from requisition and the war is over. And third, if you are not agreeable to either of the two, we will forfeit your earnest. So one of the parties, Satyaprabha goes, she thought of not accepting this proposal and approached the court saying that, well, I am prepared to wait and let the defendant company discharge its obligation of developing this land and give me the developed subplot as and when the land was released from the requisition. Matter went to the Supreme Court. And Supreme Court was called upon to examine this particular scenario with reference to section 56 of the Contract Act, because in the contract there was no provision for force majeure, therefore there was no need to look at the contract. Now on the side of the contractor, the defendant, Mugniram and company, a contention was raised. They said, look, on account of an event which is not within our control, that is requisition of the land by the government, it is not possible for us to perform the act of development, and thereby performance of the contract has become impossible. And it was further contended that though physically it may be possible at a later stage as and when the land is released from requisition to perform the contract, it would not be a viable proposition for us. The Supreme Court said that, well, there was no time limit prescribed in the contract for carrying out the development. And therefore, in that scenario, when the intending purchaser is prepared to wait till the requisition is released, the land is released from requisition, and development was possible by the defendant company, Defendant company cannot say that it is impracticable because it has to incur more cost. The Supreme Court says this is a case of commercial hardship and not a frustration of a contract. So try to appreciate. This is a case of a commercial hardship. Commercial hardship is something different from frustration of a contract, whereby physical performance of the contract is impossible, or if the physical performance is possible, that physical performance would not subserve the object or the purpose for which the contract was entered into. The Supreme Court said that even if you develop the land at a later stage, the object of the contract is not going to be anyway affected, it will be rather subserved. And therefore, the plea of the company which was in charge of development under a contract was declined to be accepted. There is one more important case on this, and that would also throw light on the query raised. And there is Alopi Prasad versus Union of India. And if I have to do a citation of that, let me just find out. Alopi Prasad versus Union of India. That was reported in AIR 1960 Supreme Court, page 588. I repeat, Alopi Prasad versus Union of India, AIR 1960 Supreme Court, page 588. Now, in this case, what happened? Again, facts in nutshell. The plaintiff, the appellant before the Supreme Court, Alopi Prasad, had entered into a contract with Government of India for supply of ghee and butter for a period of 2 years to military. The rate was fixed under the contract at which he was required to supply ghee and butter. There was no provision for revision in the rate. Now, after the contract was entered into, World War II took place, pursuant to which what happened, that it was not possible for appellant Alopi Prasad to supply ghee and butter at the rate fixed in the contract, because rates went very high and it was not possible for him to purchase or rather supply this particular products to military at the rate fixed in the contract. So he requested the government to revise the rate, keeping in mind the event which has taken place, which has given rise to the rise in the price of ghee and butter. The government declined to accede to his request, failing which Alopi Prasad refused to supply milk and butter, or ghee and butter, to the military. Government in turn levied damages, because under contract there was a provision for damages, and claim from Alopi Prasad. Matter went to the Supreme Court. Supreme Court said that, well, this is also a case of a commercial hardship, because performance of the contract was possible. Physical performance was possible. Only thing that he will have to incur losses by supplying ghee and butter to the military at the rate fixed in the contract. But nonetheless, physical performance of the contract was possible. Not only that, by doing that, object or the purpose for which the contract was executed was to be frustrated, and therefore it was construed as a case of a commercial hardship, and government was held to be entitled to claim damages from Alopi Prasad. Now, take this very principle in the present scenario, whether it is a case of electricity bill or a shop taken in a mall on a rental basis for a fixed period. You are unable to use that particular shop, you are unable to use your office, and despite that you have to pay minimum charges. Sounds nice, the argument sounds nice on equitable front. But in law, if you go strictly by the law and law of contract where equity has no place, there my answer is that this present pandemic, present lockdown will never come to the rescue of anybody who wants to claim that I may be exonerated from my obligation to pay minimum charge on electricity even though I have not used the electricity, or pay rental to the mall owner for occupying the shop which I am unable to use it. The last judgment of the Supreme Court, and which I wish all of you to read, which is also throwing light on the subject and which is a very elaborate one, a recent one, judgment, and that is the case of energy watchdog by the Supreme Court, which is a recent judgment of energy watchdog, and that is reported in, give me a minute, it's reported in 2017, 14 Supreme Court cases, page 80, judgment delivered by Justice Rohington Nariman, wherein he has discussed the case flow right from Satyabrata's case till 2017. Facts of that case in nutshell, also having a bearing on the present scenario with which we all are facing. In that particular case, what happened that Gujarat Urja Vikas Nigam Limited, we'll shortly say Gujarat Urja, a government of Gujarat company, entered into a power purchase agreement with Adani Power Limited. Now, as per this agreement, Adani Power was to generate electricity and supply it to Gujarat Urja Vikas at the tariff fixed in the power purchase agreement. Now, this tariff in the power purchase agreement was based on the competitive bid submitted by Adani Power. Now, this bid, which was its offer, was based on one important aspect, because in manufacturing electricity and supplying it, in generating electricity, you need coal as a raw material. Now, this coal, as per the practice prevalent in this trade, all companies would like to purchase from Indonesia, would like to import from Indonesia, because it was cheaper. Since last more than 40 years, this was the practice prevalent in this particular trade. And policy of Indonesia on export of coal from Indonesia to other countries was consistent for more than 40 years. Now, what happened after the contract was entered into? All of a sudden, the government of Indonesia changed its policy, changed its law on export of coal from Indonesia to other countries. Resultantly, it was absolutely unviable proposition from the point of view of cost to be incurred for Adani Power to purchase coal from Indonesia, use it for generating electricity in India and supplying it to Gujarat Urja Vikas pursuant to the power purchase agreement it had entered into. So it requested for revision in the tariff, revision in the rate at which it was required to supply this electricity to Gujarat Urja Vikas Limited, saying that, look, my bid, my offer was based on a proposition, on a consideration, which was again based on the policy prevalent in Indonesia for more than 40 years. Now, the entire scenario has gone into a great change. It's not at all economically viable for me to supply electricity by purchasing coal for the purpose of using it as a raw material. It's an unviable proposition. Let's refix the rate. Case of the Adani was based on section 56, saying that it's an event which is beyond my control. Matter went to the Supreme Court. Supreme Court examined from two angles. One, first of all, Supreme Court said that yes, this is a contract where you had a provision for force majeure. Let us look at that. The Supreme Court considered provision for force majeure. Now, there is a recent trend nowadays in the all mega contracts that when you define force majeure, you also define as to what would not be considered as a force majeure. So in this contract, there was a provision that change in the price of raw material would not be considered as an event of force majeure. So Supreme Court says your contract itself excludes these as a force majeure. And therefore, we will not consider your argument on section 56, because as per section 32 of the Contract Act, If you have made a provision for force majeure in the contract, you are governed by that. But nonetheless, Supreme Court alternatively considered the case of Adani Power under Section 56 and came to a conclusion which is relevant for today's scenario. Supreme Court said, well, physical performance of the contract is not rendered impossible. Performance of the contract in this case means supply electricity at the agreed rate or a tariff to Gujarat Urja Vikas, which is physically possible. Because if it is, it's not that import of coal from Indonesia is altogether banned. It's not that you cannot purchase coal from any other country. The only thing is you will have to incur more cost. So that is a case of commercial hardship and not the case of impossibility of performance of a contract. Impossible performance of a contract stands on a different footing from a commercial hardship. It's a commercial risk which you entered into when you entered into a contract. You ought to visualize a situation, and therefore the point which Supreme Court emphasized was in this case that merely because it was economically unviable for Adani Power to supply electricity to Gujarat Urja Vikas on account of change in the policy of export of coal in Indonesia, it cannot be said that the contract was frustrated, the performance of the contract was impossible physically, or that it was so impracticable that the very object or the purpose for which the contract was entered into would not be subserved. And therefore, Adani Power was held to be not entitled to revision in the rate. Now take the same principle here. You are unable to use your premises or shops, your offices on account of present lockdown, present pandemic. That's a commercial hardship to you. That will not render the contract which you have entered into already as physically impossible of performance or impracticable of the performance so as to upset the very transaction. Therefore, in my opinion, this present pandemic would not help in holding that respective contractual obligations have fallen to the ground. It would again depend upon the facts of the case. I am also joining a caveat here because the example which I gave of a party plot, there one can say that, well, the object or the purpose for which the contract was entered into, though physical performance is possible because that man can still have an access to the party plot even during lockdown, but it cannot be used for the purpose for which it was booked, and therefore performance of the contract, though physically possible, was impracticable in nature. Now, by way of a conclusion, first, pandemic is an event of force majeure. There is no doubt about it. If pandemic is an event of force majeure, then obviously it will have an impact on the contract, but its impact on the contract with reference to the rival contractual obligations would again depend upon the terms of the contract as also the nature of the contract. There cannot be a straitjacket formula to say that in each and every case, on account of the pandemic, the contract would stand frustrated. If any other query is there, I am prepared to answer it. Else, I would like to end my talk.
So you have given very elaborative example. So the query which was asked by the other student Kavya, it has already answered in your elaboration. With her query was that if hypothetical question it is that if company A and B has entered into a written contract which doesn't provide for force majeure clause, and A has delivered the goods and expects payment, meanwhile pandemic came. So what will be the effect of this? But you have already answered with illustration to this question.
Okay, fine. Yeah, so it's, I think it's solved. Query is solved. Any other
But
query?
one more query, sir. One more query regarding the example you gave. That Does the change in circumstance making the obligation radically different from what was originally contemplated amount to frustration?
Huh.
Uh, that is what the question is of Nathan.
You see, if the performance of the contract is not possible, if radically changed, then obviously the foundation of the contract is disturbed. If the foundation of the contract is disturbed, then obviously pandemic would be considered as an element of force majeure frustrating the contract. Because as you said that if radically the performance, the obligation is radically changed, it is not possible for you to perform the contract keeping in mind its object, then obviously the contract would be declared as void. But if it is possible to perform the contract without disturbing its object, without disturbing its purpose, but causing inconvenience to you as a performing party, then it is not frustrated. Then it's a case of hardship. Again, I repeat, commercial hardship, individual inconvenience in performing the contract cannot be considered as an event of force majeure leading to the frustration of the contract. So it would again depend upon the nature of the contract. If the nature of the contract is such whereby physical performance is possible, is not impracticable also from the point of view of its object or the purpose, then in that case the contract has to go. It cannot be said to be having been frustrated and resulting into a void contract.
Okay, so another question says that if the again hypothetical it says if the sale deed has been drafted where the possession of the property was to be given on 15th May,
Yes,
post the
right.
registration of the same property on same day.
Yes, right.
So what would be the relief
Okay,
during
fine.
pandemic?
And the pandemic takes place, possession is not possible to hand over, you meant to say, right? Okay, fine. Now again, here the issue would be whether time for handing over the possession was essence of the contract or not. If the time for handing over the possession was not the essence of the contract, and at a later stage, as and when the possession is possible to hand over without disturbing the basic purpose of the contract. Let me elaborate. Say, for example, land is to be purchased by you for putting up your residential house. It's an open land. You agreed to purchase. Agreement says that on the date on which the sale deed is to be executed, you are to be put into physical possession. Now, performance of the execution of sale deed is not possible on account of pandemic, lockdown, the registration office is closed. So, virtually handing over of the physical possession is not possible. But this is a case where time cannot be considered as the essence of the contract, because even if you are handed over the possession after the lockdown is over, the purpose for which you were to acquire the land, you were to purchase the land, is not going to be disturbed. It's going to remain the same. And therefore, the contract would not be frustrated. But as I said earlier, if land was to be, say, booked, not purchased, booked for a particular purpose, and that particular purpose was to take place on a particular day, and thereafter that land is of no use to you, then obviously time is the essence of the contract. And in that scenario, the contract would stand frustrated. I hope my answer query is clear. Still, if it is doubtful, you can still raise a query.
Okay, sir. The last one, as you
Yeah.
mentioned, Satyavrata case. A student wants to ask that Satyavrata says that time is not an essence of the contract and hence not frustration. But what
Right.
happens when time is an essence of the contract?
Yes.
So
Yes.
it amount to frustration or an alternate measure?
Absolutely. Very good question. Very good question. Now you see, say in a case of Brata, let us visualize hypothetically a different fact situation. That time was the essence of the contract, and development was to be carried out by a particular date. And if it was not possible on account of the requisition, in that case, it can be said that the contract would stand frustrated because time was considered as essence of the contract. So it would be open for either party to say that I would not like to continue with this contract, where at the time of entering into a contract, we had considered time as the essence of the contract, which had the bearing on our bargain, our obligations. But since in that particular case, as the facts revealed, that time was not the essence of the contract, and the party who was to suffer on account of delay in requisition was prepared to wait, the court ruled that yes, merely because it is more onerous to you economically to perform your contract, the company who was to develop that particular land cannot be exonerated. But if the time is the essence of the contract, obviously. But you may also appreciate one thing, that merely by mentioning in the contract that time is the essence of the contract, the time would not become essence of the contract. You see, ultimately it is required to be culled out from the intention of the parties. And therefore, if it is possible to come to a conclusion based upon the nature of the particular contract, that time is the essence of the contract, then in that case, obviously, pandemic, force majeure will have a great impact. I'll give one more example, which is what happens that suppose in a construction contract, where ordinarily in a construction of a road, where ordinarily time would not be considered as the essence of the contract. But there is a provision that if you delay the execution of the work, the contractor will be liable to pay liquidated damages. I mean, that scenario, if it is not possible to execute the work on account of the pandemic as a force majeure, obviously you can say that during this period, I may not be subjected to liquidated damages. The contractor can very well say that I should not be rendered liable for liquidated damages because work got delayed on account of the lockdown, which was on account of the pandemic, which was a force majeure event, and therefore delay in completion of the work was not attributable to me but was attributable to force majeure, and therefore I should not be penalized for that. Hope this query is also clear with this. Any other query?
Thank you, sir. It was indeed very helpful that you shed light on so many aspects of force majeure and contract. It is indeed your forte, and you truly gave so much information and knowledge to our students and all the viewers who are just watching this video and who are attending this live session and who will be taking benefit of this in future as well, sir.
Thank you very much. It was my pleasure also. I thoroughly enjoyed. Thank you very much.
Thank you. And we are once again on behalf of GLS Law College, on behalf of Dr. Mayuri Pandya, director of our institute, we thank you so much for coming here, and pardon for the initial, in the earlier lecture when it was set up due to some technicalities. It was
it was a force majeure. It was a force majeure.
It's a perfect example.
Right, sir. Okay.
Sir.
Thank you. Thank you very much.
Here.
I thoroughly enjoyed. Thank you.